All eyes are in Ada County, Idaho, where jury selection for the trial of Doomsday Cult mom Lori Vallow Daybell is scheduled to start on Monday. Vallow is charged with murder and conspiracy in the deaths of her children J.J. Vallow and Tylee Ryan, along with Tammy Daybell, the first wife of her husband Chad Daybell. He's being tried separately on similar charges. Vallow has been in jail for over 3 years after the pandemic delayed proceedings related to things like competency. Now, and a big topic expected to be brought up during jury selection is religion. You see, the prosecution says the murders were tied to the couple's extremist beliefs. But before jury selection even begins, 3 big developments happened in the case that you need to know about. So first, Chad Daybell, Lori Vallow were supposed to be tried together, but now that is not happening. You see, Judge Stephen Boyce ruled last year that the couple would be tried together in Ada County. However, defense attorneys brought up on several occasions that Daybell waived his right to a speedy trial while Vallow did not. Daybell's defense team argued that their client's case would require more prep time and that trying them together would rob them of that time. In March of this year, the judge finally agreed to sever their cases just a month before the trial was set to begin. Now, the second big change, Vallow no longer faces the possibility of getting the death penalty if she's convicted. In May of 2022, prosecutors announced that they were going to seek the death penalty in Vallow's case. Her defense team filed a motion opposing that decision last month, citing discovery violations, mental health concerns, and media attention. The motion even said, quote, "We don't kill witches anymore in America." Judge Boyce ultimately ruled in favor of the defense, and the maximum sentence that Vallow can now face is life in prison without the possibility of parole. But there's something else that you need to know, and that is that there's currently a battle going on between Vallow's defense and one of the victim's grandparents over seating in the gallery at trial. That's right. According to the court's guidelines, victims are allowed to sit and watch the trial. But Vallow's defense argued in a hearing this week that Kay and Larry Woodcock, the grandparents of J.J. Vallow, would not be considered victims in this case under Idaho law. Witnesses aren't allowed to sit in and listen to other witnesses' testimony, and there's a possibility that Kay Woodcock could in fact be a witness. Judge Boyce has yet to make a ruling on this particular matter. Let's break it down. Brian, no death penalty, being tried separately from Chad. I feel like that's got to work in Lori's favor, right?
Yes, only split the baby here, for lack of a better term, and sorry for the poor choice of words. But no death penalty makes it a little bit easier and a little bit harder, because no death penalty means that the stakes are a little bit lower, but it's harder to negotiate a plea if Lori Vallow Daybell wanted to get one, because in the prosecutor's mind, they've already reduced the case liability from death to life in prison because of a judge's ruling, so they're probably not going to get a good deal. But being tried separately is a huge win, because at the end of the day, the jury wants to find the bad person. And here, Lori can say that the bad person is the bad guy. Her husband, because she can argue, why would I kill my children? Why would I do this? I was maybe forced. I was maybe pressured. Maybe there's some sort of coercion. Maybe my mental health issues were overcome by this guy. Go get him, not me. It could work to her favor.
Well, Terry, Lori Vallow wants to keep the grandparents from viewing the trial because they may be called as witnesses. Do you think that should be allowed in?
I think that she should be able to sit, both the grandparents should be able to sit in there. They are victims, they are family. And what Vallow is arguing is, no, they're not technically grandmother and grandfather, but they raise the children as if they were their own. Now, technically, Kay may be called as a witness, that's what we have heard, but I do think that there can be some sort of compromise here where she's allowed to sit in most of the trial, but then for portions where there might be some issue, she cannot sit there. And I do think that it's a good rule not to have witnesses be in the courtroom, because they could change their testimony, and that's exactly why the judge did rule that they shouldn't be there. But these are really definitely family members. They raised them as such.
And look, while there are no cameras allowed in that courtroom here at Law&Crime, we are going to do our best to bring you updates on this trial, because we have been following it since the very, very beginning. And we're finishing off this week in Kenosha, Wisconsin, where Alan Brown was convicted on all charges Thursday for shooting a canine officer while running from police. In October of 2021, Wisconsin officers were notified that Brown was in a stolen vehicle heading in their direction. He was suspected of 2 separate homicides in Chicago that very same day. Now, Kenosha police caught up with Brown at a gas station, and he got out of the car to run. Body camera footage captures the moment that Deputy Terry Tift unleashed K-9 Riggs, and Riggs caught up with Brown and tackled him in mere seconds, but was shot at point-blank range in the top of the head. Now, fortunately, canine rigs survived with only a bruised skull, and he returned to the force just weeks later. As for Brown, the jury took less than an hour to find him guilty on endangerment, weapons possession, police evasion, and animal cruelty charges. He faces more than 70 years on the Wisconsin charges alone at his sentencing in late May. But here is where things could get a little tricky. In Wisconsin, you have 20 days to file an appeal after a conviction. And based on the performance of Brown's defense attorney, he could have some grounds. Brown was represented by public defender Addison Kuhn, and he gave a very brief opening statement for his client and remained relatively quiet throughout the trial. So quiet, at points it kind of looked like he was falling asleep. The defense called no witnesses, and Brown decided not to testify on his own behalf, but the key moments that could help Brown appeal happened during the parties' discussions of jury instructions. Check it out.
He went to talk to the defendant in the hospital, and he's an investigator, and he did say that he did Miranda warnings, but there was a conversation that took place prior to that I have a problem with, because we never had any sort of hearing.
If there's a challenge, and there never was.
It's automatic. Any objections to reading evidence?
No.
Any objections to reading circumstantial evidence?
No.
Any objection to reading information, not evidence?
No.
Any objection to weight of the evidence?
No.
Jurors' knowledge?
No.
Exhibits?
No.
Transcripts not available for deliberations?
No.
Police reports?
No.
Expert opinion testimony general?
I guess I don't know did we qualify anyone as an expert in the case?
I think we had the doctor
And crime lab
and the
analyst.
crime lab.
That's fine, yeah.
I would consider those experts because they gave opinions.
That's fine.
You know, Terry, Brown's still facing possible charges in Illinois. What happens next for him?
Well, technically, he's going to go for his sentencing. He may or may not appeal the case, but either way, we know Illinois is going to try to get him back. The charges that he's facing there are far more serious than the charges he faced in Wisconsin, and he has so many years that he could serve in Wisconsin. For Illinois, they say he killed 2 people. Basically, it is on video, so I think it's not going to be that difficult to show and prove that he absolutely, beyond a reasonable doubt, killed these 2 people in the connection with this carjacking. So I believe Wisconsin and Illinois will absolutely cooperate. They'll probably extradite him back to Illinois so he can face those charges, and then we'll see what happens. This individual is very dangerous. When he was in jail, actually in Wisconsin, he headbutted one of the guards, and he had to actually go get medical help for that. So this individual will do anything to try to escape and to try to, be free, and he clearly is a dangerous individual.
Right. Brian, it's not just sleeping in court with this lawyer. I mean, is there more of a case for ineffective assistance of counsel now based on what you saw?
Yeah, Jesse, I hope that I'm wrong. I'm hoping that with the clips that we're seeing, the portions that we've read and seeing about this case is not accurate of the full picture of what this public defender did. Because if it is in fact true that there was not a hearing based on pre-Mirandi statements, there wasn't a pushback on trying to limit the testimony that came in, there wasn't a verification that these experts were qualified. If you're guilty, you're guilty. That's fine. Go to jail. That's where you belong. But if due process wasn't given, if the Sixth Amendment wasn't upheld, if the defense wasn't zealous as everyone is supposed to get, don't be a public defender. Go do another job. This is not the job for you, because regardless of what the accusations are for a person, they deserve zealous advocacy. And if this person did not do the job that I signed up for so many years, don't do it. Don't stand in line with me, stand somewhere else.
I think very well said, Brian. I hope you're wrong too about him. Brian, Terry, thank you so much, everyone out there. Thanks for joining us here on Law&Crime Daily. We're going to see you next time as we discuss justice in America.